they have a payment provision in there whereby they have 90 days to make payment after the date of invoice. Now, that's a hell of a long time under any contract, 90 days. So you've got to think of the impact of that on your cash flow, particularly if it's a big organisation and perhaps a lot of your workforce, a lot of your time is spent on that contract. Then how are you going to fund your other business operations, pay your staff and your freelancers? How are you going to pay them if Nike aren't paying you for 90 days after the date of invoice? So as well as that consideration, Nike have also factored in that if they manage to pay you within that 90 days, and God knows how an organisation like Nike with endless amounts of money is going to manage to pay you within 90 days. If they do that, they get a 5% discount on their invoice as well. So, quite amazing. As I said, I wish I could get away with that in some of my contracts, but just things like that. Also, if you're dealing with a Nike or a Coca-Cola, Pepsi, a lot of these organizations are multinational. And so a lot of these contracts are going to be under the laws of different jurisdictions. You are so fundamental to the business that really it's the three or four of you together that is the business. What you don't want is someone down the line deciding they've had enough, they want to get out, and then you going, oh Christ, now how do we deal with this? How do we deal with someone trying to get out of this business now? So normally you'll find in shareholders agreements, rules and restrictions on people exiting a business. As I said, how, when, and to whom. So there will normally be sort of some preemption that if someone wants to leave, the existing shareholders have the first right to buy them out. If you don't have a shareholders agreement or don't have similar provisions in your articles of association, then basically anyone is free to sell shares for at whatever price they want to whoever they want. Now, in an organisation where perhaps one person is a majority shareholder, that person could probably find a buyer for their shares. They might not get what they think they're worth, but they could probably find a buyer. And then suddenly the minority shareholders could be in business with someone they never, ever wanted to be in business with. So it's really important from that point of view that everyone has absolute clarity on how shares can be transferred. The other sort of very common issue that comes up with share ownership is what happens if someone dies. And it's the same sort of thing. If you don't have any rules in place, shares will go into the deceased estate in the same way as the other assets, and they'll be distributed to whoever the beneficiaries are. And sometimes that seems quite nice because you think it's a legacy. If I build up this business, I want my spouse or my children to sort of share in that as an ongoing legacy. But actually, it's actually probably not palatable to the surviving shareholders who, are then basically building a company for some people they don't really know or have any allegiance to, and certainly who aren't, or more than likely not contributing to the future growth of the business, are then actually, earning a living off of your hard work.
And often we see in employment contracts restrictive covenants, which can then affect people's ability or employees' abilities on the face of it to work in competing businesses if they leave you, to deal with customers or clients of yours, and also to solicit business from those people after they've left you, and even solicit members of your own teams. So it's not unusual to see those types of covenants in employment contracts. There can be a big problem where they're just like standard terms. So you have a standard term template contract you use with lots of nice looking restrictive covenants in, and you have someone very junior start with you and you get them to sign up to those. The likelihood is that those covenants will be unenforceable. The starting point when you're looking at anything that's a restraint of trade is that it's unenforceable unless it can be shown to be reasonable in its extent and protecting a genuine business interest. So if you're looking to impose very strict covenants such as a non-compete covenant on a very junior employee just starting with you, that's not going to hold up. and it's not worth the paper it's written on. So restrictive covenants need to be focused on, you obviously need to consider what you're trying to protect, but also you have to look at what is appropriate in terms of the relevant employees. So those things we do see, they are important and they need to be considered carefully. One very sort of rough guide as to, well, what's reasonable is, well, how long do you think it will take you to re-establish a relationship with a client, for example? So if you've employed someone, they're then dealing with a particular client, you more or less sort of hand that client over to them. If they were to leave, how long would it take you to reinstate the type of relationship with your client? So maybe 6 months or whatever. It depends on the business, what your regular course of contact might be with that individual or that business, but those things need to be thought about in terms of deciding what's reasonable and appropriate. The other area I was just going to mention concerned the importance of having paperwork in good order when you're actually looking to sell your business. I mean, it's one of the key things if you are, to be honest, whether you're transferring shares or whether you are actually looking to sell to a third party, having all these types of things in order is very important. And whether it's in a formal TUPE context where people's contracts are transferring, or whether it's just so that a buyer knows, what their obligations will be in terms of various employees.
Will things go back to how they were before? Are we going to work in a different manner? Do we need all of the property space that we've currently got? Is there any way of maybe changing that? A lot, of course, will depend on the contracts that you've got with your landlords, the leases that you occupy under, and some of you may have break clauses in those leases, and they are usually fixed at a particular date, but some of them can be rolling breaks, and that is something that you may want to look at and think about. Well, is it something that we could go to the landlord and say, well, look, we don't want now to occupy all of this space, and we may look to break our lease. It's something that you can put to a landlord, and they may be prepared to consider to reduce the space that you're occupying in order that you don't occupy your breaks. So that's something that you can look at. Of course, surrendering leases as well is something else, but because if you've got a lease and you've got a lease for 5 years or 10 years, then that does mean that's a contract right the way through that period, and it's very much down to the landlord to decide whether he wants to take a surrender of a lease from you, and that's unlikely to happen unless the landlord's in a position to be able to relet premises. So these are the sort of things you may need to consider on the property side. Obviously, COVID has had an impact on businesses as well, and that in turn will have an impact on ability to pay rents and service charges and so on. At the moment, the Coronavirus Act 2020 is in place. It's a way of getting the parties together to try and get through this period and make sure that tenants survive and they're able to get through and carry on with their businesses. In terms of sort of the other impact that you may have with property, that really is more when you're taking leases, you've got to be very careful in terms of your liabilities and how that may impact on your business. Repairing liabilities may have an impact. All tenants will be liable to repair the premises, keep them in good repair. Internally, you may have a service charge where the landlord will repair the exterior of premises, but you will have a liability to repay the landlord a proportion of that, depending on how many tenants are in the building.